लेकिन ये आप देखिए ये जो रिव्यू एक्ट जो पास हुआ था इस एक्ट के बाद उसमें लिखा गया था रिव्यू शैल बी हर्ड लाइक एन
मैं उस पे भी आ रहा था
एंड उसके अंदर स्पीकिंग entirely for myself
and it was struck
I
down
have
on
given
that.
a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a because they've heard it before as review and half the bench is hearing it for the first time therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal and
Constitution Constitution की distinction ही खत्म हो जाती है.
Let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side. It's not
Sir,
the judicial
उसमें
order.
applications
Right.
decide हो रही हैं. अब reconsideration has become, which is in the nature
But
of a
all,
review.
all those matters in Order 5, even though, well, it passes for whatever we may call it as administrative, but there's substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure.
But
So the
Parliament
word
is-
Is
reconsideration.
it
Parliament
on
has called it
administrative
an
side, Mr. Faisal, or the judicial side?
Ji, sir.
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted.
Yeah, I don't know
The
if this
judicial
is.
side or the administrative side?
Taking that point further, I mean, whether at all these straight jackets about this administrative moving into judicial.
The
moving
point
into
is-
administrative-
Probably the bard said it best. A rose by name would smell just as sweet.
I would
So
say-
whatever you call it,
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appease as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175(2), the judgment authored by her ladyship Aisha Malik Saiba has also relied on 175(2), read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court.
So, see, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court, it's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
These are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into entry 55.
one of the questions which was raised by Justice Ejaz was that if you create a new appeal, is this enlargement or this is, because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD, that enlargement in creation of a
can
new
you give me the
appeal.
citation to?
Ji, ji, ji. Sir, this is 2021 CLD 214 at para 62-64. But let me come back
Para 62.
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal? Whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, very kindly, it's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूं,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूं सर।
आप उसमें you miss out on the jurisdiction and powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं। वो आप बताएं, आप क्या समझते हैं इसके बारे में?
और दूसरा इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज,
जी,
इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है,
मैं
कहाँ
मैं
पढ़ना
कह रहा हूं। Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your Lordship, Ladyship, may just keep your eye on the word jurisdiction and power because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now, the
और
Supreme,
अंडर से पढ़े ना, और अंडर।
जी जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is
Okay.
not. But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
or
part.
both?
Second part.
Second part.
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But
एंट्री नंबर
that power,
55 में मिस्टर फैसल ये जो दो लाइनें हैं ना, with respect to of the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए।
ये तो कोर्ट्स के लिए हो गया, ये हमारे लिए
से
relevant
शुरू हुआ, वो फिर आगे सुप्रीम कोर्ट का तस्करा।
जी जी जी, अब सुप्रीम कोर्ट।
हाँ चल, इसके मानी पे एक्सटेंट के।
और
अब
इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes,
We explain
but
that.
it is by or under. That is critical.
No. You see, express means express.
No.
It can't be implied.
By-
When it says express, then it has to be express.
I'll
You
explain.
can't read
Let me
implied
just
into it.
explain the other two restrictions and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir, I'm
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. I mean, it's just on the lighter side.
If we stop him, we won't be able to argue.
No. I just find very refreshing it.
Article 2 is the only exercise I get, sir. Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your Lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly
But
authorized,
expressly,
yes.
वो बताएं वो कहाँ है?
उसका क्या
Sir,
मानी
मैं
है?
एक मिनट second part पढ़ लूं जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
पावर दोनों है
Parliament
ना, एक तो enlargement का भी है।
of law and constitutional principles which the petitioners have placed before your Lordship, one is the Kakar case. PLD 2012 Supreme Court. And the other is a recent judgment of this court, the Ghulam Muhyiddin case. Now, if the petitioners are correct in terms of their reading of these judgments, then in terms of these judgments, this law would be unconstitutional. So my submission on this legal precedent would be crucial. I'll be making the submission that as far as the Bas Kakar case is concerned, PLD 2000 Supreme Court, that is clearly distinguishable in terms of the law which was involved, the Contempt of Court Act 2012. But as far as Ghulam Muhyiddin case is concerned, which concerned the Review Act which was part, I would be respectfully submitting before your lordship that parts of those judgments have to be revisited. Not the entire judgment, but parts of that. Let me come to my...
have to be
revisited. But only parts of that judgment, my lord. My lord, if I may take your lordship to my first submission. And my first submission as his lordship, what I've done is that I framed the questions and then I framed short answers and then I'll make submission. Let me just read the question. The first question is, and this is a question I think which has been telling her ladyship, Justice Aisha Malik, whether the term law occurring in Article 191 Constitution 1973 includes acts of parliament, whether the term law occurring in Article 191 itself confers legislative competence and or requires legislative competence to be based on some other provision of the Constitution and or legislative entity in the fourth schedule. If the Parliament has the power to enact a law, enact such a law, then what are the limitations of such a law? My lord, if your lordships may turn to the third page of the brief note which I've given your lordship, and the heading is B, where I deal with this question. No, my lord, the term subject to. Now, question has occurred and repeatedly been asked, is this conferment or is this restriction? What I would be submitting before your lordship is that it is both. It has two parts, subject to and law. So subject to restricts and law confers. Now, let me first clear I think it is a confusion which has occurred, whether the term law as used in Article 191 means or includes acts of parliament or not. My lord, in order to understand this, my lord, let us first go to the Supreme Court rules and let us examine how the Supreme Court, full court in 1980 which sat, looked at this term law, and the answer lies in that. If I may take your lordships to the Supreme Court rules, Order 11, which is the critical section dealing with the Chief Justice being the master of the roster. How did they understand this term law? If your lordships have Order 11, my lords. If I may read, and I'll only read the first line, critical line, save as otherwise provided by law or by these rules. Now, your lordship may notice the language in this. Save as otherwise, critical word, otherwise, provided by law. My lord, a bare reading of this provision shows that one is envisaging some kind of statutory law. And I will come to the words otherwise later. Otherwise indicates that if law here refers to act, there may be some other arrangement in some other statute.
Subject to otherwise provided by law what? पूरा पढ़िए ना इसको.
By law.
No, kindly read the whole.
Save as otherwise provided by law and by these rules, every cause.
Or by these rules. Or by these.
Or by these rules, every cause, appeal or matter shall be heard and disposed of by a bench consisting of not less then 3 judges to be nominated by the Supreme Court.
Well, this goes to the of the bench, not who is to sit on the bench.
Sir, I'm not coming to, I'm simply saying, how do we understand this term law, which occurs in Article 191? An indication of that is given in this order. This clearly implies some kind of statutory law, and I'll come to the words otherwise later when I examine what is the relationship between rules and act. Now, to further clarify that the word law must include an act of parliament, there is a definition section in this Supreme Court rules. Now, your lordship may kindly come to that. If your lordships may kindly see order 2.
Mr. Siddiqui?
Yes.
The question was that if it is only to be an act of parliament, then the constitution might have used the word act of parliament, not that the word law includes act of parliament. The whole issue was that subject to law, law is a very broad term,
Yes.
includes many things,
Yes.
including an act of parliament.
Yes.
And the Attorney General said that we should read into the word law the fact that it's just an act of parliament. Hence the issue as to how to read the word law. तो आप जो बहस कर रहे हैं कि लॉ में एक्ट ऑफ पार्लियामेंट है वो तो अंडरस्टूड है, सिर्फ ये है कि टू द एक्सक्लूजन ऑफ एवरीथिंग एल्स हम इसको लॉ में पढ़ेंगे.
The exclusion argue nahi kar raha hu, and the reason I am trying to clarify so that there is no confusion is to come to my argument about conferment under Article 190. If I may just make one point on this.
You see, there are two issues
Yes,
here.
yes.
I interject now. I'm here to hear you. Please conclude your submissions. If someone wants to ask a question, if you start responding to each query, I don't even know what your argument is. And I would request the honorable members of the bench to at least let counsel complete his submission. Yes, there will be questions, but I don't know what you're going to say next. And if you are faced with questions, I mean, I don't know what I'm to write, and I just lose the chain of thought, and I'm sure you do as well. So, Mr. Siddiqui, please, if you keep responding to each question, we'll be forever. No, excuse me, this is no laughing matter.
Well, Lord,
No, from morning to night on the first day we worked, every second of this court is time of the people who have invested heavily in this institution. 3 full days have worked. Now we are on the 4th day. We can endlessly hear one case in the year, and that's a performance. And all the other cases will get left behind, and all mounting up. So please, there are 15 of us, and all of us have questions, and undoubtedly valid questions. Please complete your chain of thought, and if you keep responding, I don't know what your contention is, I will never understand it.
if I may just complete this.
Please keep submitting your submissions.
I'm very grateful to your lordship.
It
does. It does.
Okay, you insist that it does.
No, I don't.
Competence, even if it is couched in negative terms.
I think negative is a relative word.
And it
If
would
it
have
Says
to,
no court, what else could
and,
be a
and
negative?
since, and since law can here mean provincial law, it likewise confers it on provincial law. So what is then to prevent a province from saying, we are conferring a right of appeal on the Supreme Court relying on this 175(2)?
Because
here is our law, we are conferring a jurisdiction.
Because they would be barred under entry 55.
That's the whole point.
Yes.
That therefore validly enacted law.
Let me explain this, if I may read a passage. Exactly the same problem came before the court. 2021 CLD 214, para 63. Both these provisions are dealt with.
Section 44 of the Competition Act के अंदर अपील है against the
तो फिर
appellate
उसमें
tribunal.
यही सवाल आ गया ना कि
मैं उस पे आता हूँ प्रोसीजर
नहीं, ये जो कॉम्पिटिशन एक्ट ने अपील प्रोवाइड कर दी, जो सवाल ये है कि वेयर इज इट मेंशन्ड एक्सप्रेसली
जरा देखिएगा इसी में
इन द
जवाब
कॉन्स्टिट्यूशन
है।
फॉर,
अगर आप देखिएगा इसी में जवाब।
ये 175(2) के तहत ही largely होती
जी जी, अगर आप देखिएगा पैरा 62, it's the exact problem which her ladyship Justice Aisha Malik has dealt with. Exactly the same.
Para 62 is in
62.
on which page?
293.
293. Thank you.
सर पैरा 62 में मैं पहला पैराग्राफ नहीं पढ़ूंगा, अगर आप देखिएगा एंट्री 55 रिप्रोड्यूस्ड है।
ठीक।
ठीक, उसके नीचे मैं पढ़ रहा हूं. There are two parts to entry 55. Have your lordships found?
Yes.
There are two parts to entry 55. The first part allows Parliament to legislate on the jurisdiction and powers of all court in respect to matters in the FLL, which is the Federal Legislative List. The Supreme Court has been excluded from this part, meaning that Parliament cannot legislate on the jurisdiction and power of the Supreme Court in so far as the entries in the FLL. The second part of entry 55 deals with the enlargement of the jurisdiction of the Supreme Court of Pakistan and confirming of supplemental, sir please, confer supplemental powers as well. Article 175(2) of the Constitution states that no court shall have jurisdiction save as is conferred on it by the Constitution or by or under the law. Article 175(2) of the Constitution gives Parliament competence to confer jurisdiction on the court by or under a law. The question is, does this include the jurisdiction of the Supreme Court? When Article 175(2) is read with entry 55 of the first part of the FLL and Article 142 of the Constitution, Parliament is competent to make law enlarging the jurisdiction of the Supreme Court and conferring supplementary power, which is provided by the Constitution, by or under the Constitution, meaning that the constitutional jurisdiction of the Supreme Court of Pakistan cannot be taken away, but where the Constitution authorizes on jurisdiction, it can be enlarged. So these are the two
question again is,
judgment, has it been assailed before this court?
Yes.
क्या हुआ उसका?
No, it's not suspended. I think leave grant to me.
इसे निकालिए, ये आप तो चेक कीजिए, ये इसके नंबर ले लीजिएगा, बता दें.
Sir, मैं भी CCP को उसमें leave grant to suspend नहीं.
Is it unanimous or is it a unanimous judgment?
Sir, on certain issues,
on this issue,
on this issue, all three agree. All three agree. Okay. On this issue, which is given at the last para of her ladyship's judgment, अगर आप वो भी देख लें, उन्होंने बताया किस पे डिस्प्यूट है, किस पे नहीं है.
but Mr. Faisal, my problem with perhaps this judgment also, or otherwise, is that how do you pass this, the test of expressly authorized by or under the Constitution? So what I would understand from this is that somewhere in the Constitution it must expressly talk about enlargement of the jurisdiction.
Not the enlargement. Not the enlargement. Enlargement and supplemental are restrictions. Apart from that, you cannot. But enlargement of the jurisdiction and supplemental powers is the restriction imposed on Parliament's powers when it legislates on the jurisdiction and powers of the Supreme.
Let me just finish with this judgment. Can you tell us the background of this judgment? What had happened?
Sir, जो Competition Act है उसकी varies challenge हुई थी, and one of the provisions which was challenged was that how can a direct appeal be provided from a statutory body through a statute? That was one of the questions.
Sorry, come again.
Sir, how can a direct appeal be provided to the Supreme Court through an ordinary statute?
It was to the Supreme Court.
Yes. And what is the legislative?
Against?
Sir, Section 44 Competition Act.
Against whose order?
Sir, वो order होता है Competition Appellate Tribunal
के order के.
So, in the nature of a service type matter, direct to the Supreme Court.
Direct to the Supreme Court. Election Act में भी है. But the question which was answered was one of legislative competence. कि कहाँ से power आता है?
इसमें तो अगर आप देखें ज़िंदगी साहब, आर्टिकल 185 में 185 में सिर्फ अगेंस्ट
चाहे वो स्टेट ऑफ इजराइल है, चाहे वो इंडियन फोर्सेस हैं, और खुल के हमें सपोर्ट करना चाहिए हक और सच का, और अमन का रास्ता निकालना चाहिए। और अमन का रास्ता तभी निकल सकता है जब उनको उनका राइट जो है ज़ायनिस्ट के खिलाफ میں کسی بھی مذہب کو ایکسٹریمزم سے نہیں نتھی کر سکتی. ہر مذہب امن سکھاتا ہے, مگر مذہب کی بیسس پہ جس طرح مسلم پیلسٹینینز کو جس طریقے سے ان کو ایکسٹرمنیٹ کیا جا رہا ہے, ان کو ایکسیکیوٹ کیا جا رہا ہے, ان کو مرڈر کیا جا رہا ہے, ان کا جینوسائڈ کیا جا رہا ہے, وار کرائمز کیے جا رہے ہیں, یہ وار فوٹنگ پہ اس کام کو روکنا پڑے گا. اگر گلوبل پاورز اس وقت نہیں سامنے آئیں گی ان ایکشنز کو, اور جس طرح کی اوپن تھریٹس اسرائیل دے رہا ہے اور وہاں پہ مسجدوں کو شہید کر رہا ہے, قرآن پاک کی بے حرمتی کی جا رہی ہے, جس طرح انسانیت دفن کی جا رہی ہے, جب تک اس کو روکا نہیں جائے گا اور اس کو ٹیبل پہ ریزالو نہیں کیا جائے گا. اور پیلسٹینینز کی اپنی زمین ہے, غازہ ان کی اپنی زمین ہے جس کے اوپر قبضہ کیا اسرائیل نے, وہ آکیپائرز تھے, اور پھر اس کے بعد جب انہوں نے ریزسٹنس فورسز نے جب ری آکیپائی کر دیا ہے غازہ کو وہاں پہ, اور اب ان کو کہا جا رہا ہے کہ ہم یہاں پہ کارپیٹ بامبنگ کریں گے, اسرائیل نیتن یاہو کہہ رہا ہے, اور یہاں پہ ہم لوگ ربلز میں تبدیل کر دیں گے. تو جس خوفناک صورتحال پہ یہ جا رہا ہے, یہ وہی ہے جو مودی کر رہا ہے مقبوضہ جموں کشمیر کے اندر. تو ورسٹ ہیومن رائٹس کی جو باربیرزم, جو بروٹیلٹی اور جو اپریشن ہو رہی ہے, وہ دنیا کے اندر یہ دو سب سے اپریسڈ نیشنز ہیں, اور جہاں پہ کوئی انسان ہونا ہی سب سے بڑی سزا ہے. تو ان کے بھی جو پرزنرز ہیں, جو ان کے ساتھ وار کرائمز جو کیے جا رہے ہیں, اس کے اوپر میں بہت سیریس, کیونکہ یہ تو میری اپنی ذات کا ہے, جس طرح ہم کشمیر کی آزادی کی تحریک لیڈ کر رہے ہیں, اس طرح پیلسٹینینز کی پرابلمز کو ہم سمجھ سکتے ہیں, اور اس کے لیے بھی کچھ لائے عمل میں اپنی طرف سے پرائم منسٹر کو بھی تجویز کروں گی, اور اپنی پرسنل کیپیسٹی میں بھی جو ہے انٹرفیتھ ہارمنی کی اس وقت بہت ضرورت ہے. انٹرفیتھ ہارمنی اور پیس ایکٹیوسٹ کی ڈیلیگیشن جائیں, چاہے وہ ایجپٹ جائیں جہاں وہ زخمی سارے وہاں پر آئے ہوئے ہیں, چاہے غازہ میں کسی طریقے سے سیف انٹری کرائی جائے, وہاں پہ لوگوں کو فرسٹ ایڈ پرووائڈ کی جائے, ان کو ایئر ڈراپنگ آف فوڈ سپلائیز کرائی جائے. وہاں پہ بالکل ہی لائٹ ساری بند ہے, وہاں پہ ایک اندھیرا ہے, وہاں پہ جس طریقے سے ربلز میں تبدیل کیا جا رہا ہے, وہاں پہ ڈیمالش کی جا رہی ہیں ان کے گھر, ان کی بلڈنگز, ان لوگوں کو جس طرح ٹارگٹ کیا جا رہا ہے. اور یہ 21st سینچری ہے, اتنا خوف آتا ہے جو کچھ وہاں پہ ہو رہا ہے اس وقت. تو اس لیے اس کے اوپر میں جتنے بھی دنیا بھر میں اپیل کرتی ہوں ہیومن رائٹس کے جو ایکٹیوسٹ ہیں, جو پیس کے ایکٹیوسٹ ہیں, کہ خدایا ہم لوگ پیس کے لیے اپنے ہاتھ سے ہاتھ ملا کے ہم لوگ نکلیں اور امن کے راستے پہ نکلیں, امن کی شمع جلائیں اور پیلسٹینینز کی آواز بنیں. وہ حق اور سچ پر ہیں, اور دنیا نے پچھلے 76 ایئر سے سب سے پرانا مسئلہ کشمیر اور پیلسٹائن کا یونائٹڈ نیشنز کے ایجنڈا میں.
یہ بتائیں کہ آپ نے اڈیالہ جیل کا بھی وزٹ کیا, ایک خاص جماعت جو تحریک انصاف ہے اس کی جانب سے یہ الزام لگایا جا رہا ہے کہ ہماری جو خواتین ہیں جیلوں میں, خصوصاً اڈیالہ جیل میں 2-3 خواتین خود بھی آئیں, انہوں نے بھی یہ الزام لگایا کہ ہمارے ساتھ جو انسانی حقوق کی خلاف ورزیاں کی جا رہی ہیں. تو اس پر آپ کیا کہتی ہیں, کیا جیلوں میں ایسا واقعی ہو رہا ہے تحریک انصاف کی خواتین؟
دیکھیں, کسی بھی قسم کے پرزنرز ہوں, چاہے وہ پولیٹیکل پرزنرز ہوں, چاہے وہ نان پولیٹیکل پرزنرز ہوں, فنڈامنٹل جو رائٹس ہیں بیسک, ہر پرزنر میرے لیے ایکول ہے. بیسک میری کنسرن ہیومن رائٹس منسٹری کی اور میری اپنی جو پوری جدوجہد ہے انسانیت کے لیے اور کشمیر کاز کے حوالے سے, تو وہ یہی ہے کہ جو بھی پرزنرز ہیں ان کو اچھی ہیلتھ فیسلٹیز ملی وہاں پہ, ان کو وہاں پہ جو ہے ایک ہائیجین انوائرمنٹ ہو, فیملی سے ملنے کی ان کو اجازت ہو, ان کو لیگل کاؤنسل ایکسیس ہو, ان کو فزیکلی پروڈیوس کیا جائے. اور جہاں تک ان کے کورٹ کی بات ہے, وہ عدالت کا معاملہ ہے, وہ سب جوڈس معاملے ہیں, اس کے اندر کیونکہ ہم سب پڑھے لکھے ہیں, اور اس کے اندر کوئی بھی انٹرفیئر کرے تو وہ آئی تھنک وہ بہت ہی انسیولائزڈ ہو جاتا ہے. اور آئی تھنک وی شوڈ ناٹ پٹ پریشر آن دا جوڈیشری, جو بھی جوڈیشل ہمارا سسٹم ہے وی شوڈ ریسپیکٹ اٹ. مگر جہاں تک پریزنس کی بات ہے, میں خود ان کے دورے کر رہی ہوں, اور اڈیالہ جیل کے اندر بھی جو مجھے وہاں سے میں نے خود بھی رپورٹس لی ہیں کہ پرزنرز جتنے بھی, چاہے اس میں سیاسی ہیں, غیر سیاسی ہیں, یا جو بھی ان کے کیسز ہیں, کہ ان کو فیملی سے ملنے کی اجازت دی جا رہی ہے, اور ان کو کورٹس میں بھی پروڈیوس کیا جا رہا ہے, اور ان کو ان کے جو لائرز ہیں وہ بھی ان کو مل رہے ہیں. یہاں پہ بھی جا کے میں یہ ساری چیزیں چیک کروں گی, اور سامان بھی لے کر ہم جو بھی یہاں پہ جو بھی بچے ہیں, اسپیشلی مجھے سب سے زیادہ جو پین ہوتی ہے چھوٹے چھوٹے بچوں کو پریزنز میں دیکھنا, اور خاص طور پہ وہ بچے جن کی مائیں یہاں پہ اریسٹڈ ہیں اور وہ کہیں اور جا نہیں سکتے, تو ان کا کیا قصور ہے. تو ان کی بھی کاؤنسلنگ ہو, کاؤنسلنگ سیشنز بھی ہم ارینج کروانے لگے ہیں, اور ان کی بھی تھیراپی ہو, اور یہاں پہ ان کو ایک ہیلدی انوائرمنٹ, پلے گراؤنڈ ہو, اچھا اسکول ہو, وہ بچے جائیں, اور ایٹ لیسٹ ان کا یہ جو بچپن ہے یہ نہ کھو جائے کہ انہوں نے آنکھ ہی جیل میں کھولی, ان کا نہ گناہ نہ قصور.
اچھا میڈم, یہ بتا دیجیے کہ آپ نے اڈیالہ جیل کا وزٹ کیا ہے, وہاں پر جو پولیٹیکل قیدی ہیں ان سے آپ کی ملاقات ہوئی, خصوصاً جو ایک جماعت کے سربراہ وہاں پہ قائد ہیں, उस हवाले से हम आपसे पूछना चाह रहे हैं, उनसे आपकी मुलाकात हुई?
देखिए मैं लास्ट टाइम जब गई थी तो जिनकी आप जिक्र करें वो नहीं थे, मैं सबको मिली हूँ और मैं यकीन करें मेरे लिए सारे प्रिजनर्स, कोई रेडी वाला है, किसी ने छोटी सी चोरी की है, कोई बड़ी चोरी की है, कोई वैसे अपने आप को बेगुनाह कह रहा है या बेगुनाह है या नहीं है या कुछ भी है, मेरे लिए सारे इक्वल हैं क्योंकि जो मैंडेट मुझे मिला है मुझे वो 22 करोड़ अवाम का मिला है और उसके अंदर जो भी हैं आप सब इक्वली रिस्पेक्टेबल हैं, चाहे वो बूढ़े हैं, बुजुर्ग हैं, बच्चे हैं, मर्द हैं, औरतें हैं। और क्योंकि मेरा कंपैरिजन मकबूजा जम्मू कश्मीर की मैंने जेलों में आंख खोली है, हम लोगों ने देखा है वहाँ की बर्बरियत, तो उससे ज़मीन आसमान का फ़र्क है यहाँ पे क्योंकि जब आपका पॉलिटिकल प्रिजनर्स पाकिस्तान के उनको फिजिकली प्रोड्यूस किया जा रहा है, उनकी फैमिलीज उनसे मिल रही हैं, उनको लॉयर्स की एक्सेस है, आगे जज जानता है जज ने फैसला करना है, उसमें तो कोई प्रेशराइज नहीं कर सकता, मगर उनको वो सारी ड्यू जो फैसिलिटीज जो लीगल हैं जिनीवा कन्वेंशंस के मुताबिक राइट्स ऑफ प्रिजनर्स वो उनको जो मिल रही हैं, जिनको नहीं मिल रही हैं उस पर हमने काम करना है। बहुत शुक्रिया।
इंसानी हकूक़ के लिए वज़ीर-ए-आज़म की मुशीर मिशाल मलिक मीडिया के नुमाइंदों से गुफ्तगू कर रही थी। उन्होंने कहा कि इसराइल में जंगी जराइम किए जा रहे हैं, इसराइल जंगी जराइम का मुर्तकिब हो रहा है और फ़लस्तीन में इंसानी हकूक़ की सरीहन खिलाफ वर्जी की जा रही है, फ़लस्तीनियों की नस्ल कुशी की जा रही है। नाज़रीन, सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत जारी है।
There is a bar in the constitution itself that no appeal can be provided. For example,
I'm not talking restriction, enlargement. You want to enlarge it.
Let's take the example of the law reforms ordinance. Now, Article 199, as His Lordship Justice Mandokhail pointed out, it's a constitutional judicial forum. Now, the appeal under that is provided under a statute.
You see, Mr. Siddiqui, law reforms ordinance is a totally different species. It was a continuation of letters patent. It was a continuation of other provisions, and plus, subsequently, it was saved under Article 270. So, I mean, there are no parallels. I mean, you are comparing apples with oranges.
Sir, I'm comparing apples with apples, and I'll explain
Certainly, you are trying to do, but as far as I'm concerned, I'm so far.
You compare Granny Smiths with Granny Smiths.
But the question, you know, again, I mean, reflecting, adding to
I'll come to the second part also.
You see, here you're creating a jurisdiction for the reason that the appellate jurisdiction is provided in 185. Fine. Now, 185 does not either talk of, it neither talks of an intra-court appeal, nor it talks of any other appeal envisaging something happening within the Supreme Court. What you're doing is, you're creating a new jurisdiction.
Yes.
You're creating,
yes.
You're not enlarging. And when there is a creation, then the creation can't be done under item 55.
Enlargement of
and it cannot be done in exercise of powers under either 175(2) because that is also restrictive, and Article 191 that is also restrictive. So there are restrictions all over the place, and intentionally so. So that if an appeal be provided where the lawmaker or the framers of the Constitution consciously, deliberately did not provide one, then the matter should go back to them, and under the new circumstances, if they consider it appropriate, they can amend the Constitution and specifically provide an appeal. Using supplemental powers, using ancillary powers, I mean, that is, I think, stretching the Constitution much what it is originally
my response to
for.
the latter questions is, there is no bar under Article 199. There is no bar under Article 185. There is no bar under Article 184(3) that you can't provide an intra-court appeal through an ordinary statute. There is no bar.
Mr. Faisal Siddiqui,
Where is the bar?
Where the language used is express authorization, that is the bar. But you have to have express authorization within the Constitution in order to utilize.
What more express bar is required than Article 175(2)?
175(2) does not confer legislative competence.
if I may add to what my learned colleague is saying, you see, it seems to me that the proper context of this sentence from this judgment at page 293 that you are so strongly relying upon, and great respect. I think you're taking it out of context. But anyway, I think that is perhaps expanded upon at page 295.
सर
Kindly
पैरा
उसमें
अगर
जो
बता दीजिएगा
पेज 295
सर
वो
वो
पैरा 63 इसमें जो अंडरलाइन पोर्शन है ना वो जरा देखें इसमें एक जजमेंट सुप्रीम कोर्ट की रेफर्ड टू है और उसके बाद उसका आई डोंट नो वेदर इट्स कोटिंग फ्रॉम इट्स कोटिंग फ्रॉम अ जजमेंट वो उसमें देखिए जिसको पैरा अंडरलाइन किया हुआ है जो
जी वो 2000 एससीएमआर जो कोर्ट की
उसमें उसके अंदर शायद दैट एक्सपोर्ट्स दैट 175(2) पॉइंट इन प्रॉपर कॉन्टेक्स्ट पढ़िए तो सही सुखानी पढ़िए ये जो अंडरलाइंड है ना
अंडर एंट्री 55
अंडर एंट्री 55 ऑफ द फेडरल लिस्ट
सॉरी आई एक्चुअली हैव द
पेज 295 जहां
अगर आप पैरा काइंडली अगर बता दें
पैरा 63
का सेकंड
पैरा 63
सेकंड कॉलम थर्ड पैराग्राफ
इसमें if the entry 55
if entry 55 was not there in the FLL, it could be argued that Article 175 2 of the Constitution in respect of matters relating to cooperative societies exclusively failing under the competence of the provincial legislature, a law can validly be made by the provincial legislature, enlarging jurisdiction of the Supreme Court and conferring on its supplementary powers. But Article 175(2) is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and the entries in the legislative list. Under entry 55 of the federal list, federal legislature is competent to make laws regarding jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in such list. The other part of the entries makes the federal legislature competent to make laws enlargement of the Supreme Court and conferring thereon the supplementary powers with the proviso that this is to ascend is expressly authorized or under the Constitution. Powers and jurisdiction conferred on the Supreme Court by the Constitution can neither be inferred with or varied or taken away by legislature. However, jurisdiction of the Supreme Court can be enlarged and supplementary powers can be conferred on the Supreme Court by law in view of Article 175(2) of the Constitution and entry 55 read with Article 142A of the Constitution leaves no doubt that such enlargement of the jurisdiction and conferment of supplementary power can only be done through law made by federal.
So this is the point, I think. This explains the context of what that sentence says, because what this passage is telling us is that the jurisdiction of the Supreme Court can be enlarged. 175(2) does not do that, but for that there must be validly enacted law, for which you have to look not to 175(2) but to entry 55 read with the Article 142A. So this is the context.
142A says you look at the entry.
That's what I'm saying.
Yes.
The two have to be read together.
Yes.
But what this passage makes clear is
yes.
that 175(2) is not a standalone power in jurisdiction, because at the beginning of this para, the Supreme Court gives the example. If that were so, which is what I also put to you, then law could include provincial law, and therefore a province could say, well, we enlarge the jurisdiction of the Supreme Court. Supreme Court is saying, no, that is not correct. That 175(2) is not independent. All that it tells us is, yes, jurisdiction can be conferred on any court, including the Supreme Court by law, but that law has to be 55 and 142.
142A. There is no other third provision which is cited for the Competition Act.
लेकिन आप जो कह रहे हैं ना, आप जो उस जुमले को जो पढ़ रहे हैं at page 293 पे, as though that is intending to give a standalone competence in terms of 152, I don't think that's correct.
Mr. Faisal Siddiqui, if I go along with that, actually, so, Therefore, I don't understand how Competition Commission can confer a jurisdiction on the Supreme Court.
That's a big problem.
Unless it cannot, because it has to be, we have to pass through the same test as we have to pass today, that is expressly authorized or by or under the Constitution. So if 175 is out, then where is that expressed for, even for competition, election, and or the other four different statutes,
There
as
is
well as
also a law,
184?
Faisal Siddiqui Saab, there is also a law, Newspaper Employees Condition of Service Act 1973, in which also the appeal is provided direct to the Supreme Court. There is no appeal in the High Court, but it is against the conviction awarded by the Implementation Tribunal. So this is also direct appeal under Section 13A of the Newspaper Employees Condition of Service Act 1973. So competition, newspaper employees, contempt of court. There are three laws at least.
Yes,
And there are two,
since nobody has given us me the background, there's a competition commission has given authority to the Supreme Court or the Act?
No, the Act. There is a provision, Section
Okay.
44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
सर मैं हाई कोर्ट में नहीं था इसलिए मैं ज्यादा कहना नहीं
लिखा क्या
चाहूंगा
जजमेंट में उससे?
उधर एक
Bismillahirrahmanirrahim. Mr. Chairperson, Honorable Ministers,